thank you everybody for actually being willing to listen to me. You know, I've been to court so many times over the last 37 years, and it didn't seem like anybody was listening to me. So it's a very nice change. As Tony said, I have spent 37 years, and before I get started, you know, the last 3 speeches I gave, I forgot to introduce my wife, who's right over there, Maureen. The love of my life, and she motivates me every day. So, and we do this for our wives and our children. And I'm doing this for my daughter and for grandchildren and for all the children in Idaho who need to grow up free. So ladies and gentlemen, I 37 years ago when I started practicing law, I didn't know it was a career that you could make a living at. I thought, because my dad, his father came from Greece, and he practiced law as a passion. He practiced law because he said that God gave him that talent and the ability to help people. And so I wanted to emulate him, and that's why I took up the law practice. And my law practice over the last 37 years has been like that. We haven't gotten rich, haven't gotten famous, haven't had any power. I have no other motivation other than to use my time and my talents that God gave me in an honorable way, so that when I finally face him, I'll be able to say, I have served you faithfully, and I have done the best that I was able to do with the talents you gave me. So, and over the course of my 37-year career, many times I've represented people who didn't have any other place to turn, had nobody else to turn to, and I've done a lot of that for free because, again, I know you can't outgive God. So in that course of that practice, I developed a passion for the Constitution because I saw many people whose rights were not being protected because they either didn't have the money or the resources or the power or the position to protect themselves. And I have done that without regard to who it was or who they represented, so long as their rights needed defending. I faced the Attorney General's office in the state of Idaho 4 times on 4 constitutional issues. And if you ever hear our incumbent Attorney General speak, you'll hear him say that he defends the Constitution. Well, I faced him on his office. Actually, he's got 112 attorneys. I never did meet him until I finally ran in this campaign. But in those cases, each time they said something was constitutional, I won all 4 of those cases. And in all 4 of those cases, the court said what they were doing was unconstitutional. I think you have to understand the Constitution in order to defend it. And we have an incumbent who, unfortunately, his interpretation of the Constitution doesn't always accord with what it actually is. Because you first have to understand, the Constitution had a meaning that the founders intended. It does not have a meaning based on what you want it to mean now. So, I'll just give you kind of a brief of the 4 cases that I had with them. The first one had to do with initiatives. When I took the initiative case for the Coalition for Bears, it was almost impossible for the people of Idaho to put anything on the ballot. Well, both the federal and the state constitutions provide for initiative and referendum. That's the power of the people to legislate. Because all power resides in the people. And that you shouldn't ever forget. Well, in Idaho, it was impossible for the people to get things on the ballot. So I brought suit, and we had all of the restrictions on Idaho initiatives declared unconstitutional and removed. And we've had a lot of initiatives since then. Some I like, some I don't. But the point is, the ballots opened up to everybody, and to the people, who should be the original legislators. The second case that I represented, that I handled against the state of Idaho, had to do with independent candidates for president. I actually represented Ralph Nader, of all people. But he was unable to get on the ballot here because they made up different rules for independent candidates to be eligible as opposed to the major parties. And I felt that violated the basic principles of our Constitution, which are that everyone should have an equal opportunity to run for political office, regardless of whether they're in a party or not. And so we struck down Idaho's laws making different rules for independent candidates for president. But I'm only known for the case that I brought on behalf of the Republican Party because everybody wants to say that it's talked about me at least, that I'm not in favor of a free democracy, a free republic, and I don't represent everybody. So they only want to talk about the Republican Party closing its primary. But if you understand, I represented the Republican Party to protect its constitutional rights. Constitutional right of free political association so that Republicans can choose the Republican candidates to run in the general election. And that right is so important. Our Supreme Court has called it the most fundamental right that guarantees all others, the right of political association. I've now been hired by the Utah Republican Party because the millionaires in Utah have eliminated, through an initiative process and now a bill just passed, eliminated the caucus convention system in Utah. The caucus convention system required all of the legislators, from the governor and the executives from the governor on down, to actually take part with the party, to sit with them, to deal with them, to be responsive to them. That has been eliminated in Utah, and I've been hired as soon as this primary is over to go down and have that statute declared unconstitutional. But the reason that's of interest is this. While I was in Utah about 3 weeks ago, had the opportunity to sit down with Sean Reyes. Sean Reyes is the Utah Attorney General, and we sat down and we talked about the federal government and its overreaching into the states, and his passion, which is to reclaim Utah's lands from the federal government. And we had a very interesting conversation because that's my passion as well. 63% of the state of Idaho is held in the hands of the federal government. They took it in trust in 1890 when we became a state, with the promise that we were going to get it back, that they were going to hold it in trust for us, administer it, and we would eventually get it back. But in 1976, when they passed the Federal Land Policy Management Act, the federal government decided, no, we're going to try to keep those lands. 2009, the Supreme Court said, no, you can't do that. So we have the power, under the 10th Amendment, under our Enabling Act, under the Equal Footing Doctrine, which says that all new states admitted to the Union stand on the same terms as the original 13 states. We have the absolute right to demand our lands back. Amen. So I wondered, why haven't we done something about this? Because I found out that Utah, Arizona, Nevada, Wyoming, and Montana are all doing something about this. And I found out that in their discussions with our incumbent Attorney General, he's not interested, doesn't think we have a case, and isn't going to do anything about it. Ladies and gentlemen, that means we lose $1 billion every year in revenue to the state of Idaho and the people of Idaho. $1 billion a year, because that's just the amount of timber that we harvest by burning it down in the federal forests, instead of harvesting it, creating jobs in Idaho, and increasing our economic independence. We would be able to cut the strings to the federal government, eliminate all the need for any federal involvement in our state, and be completely independent if we just got our lands back. Yeah. Primary reason that I am running for this office, because that is the heritage of our children. It's ours. We need to be independent of the federal government. We need to stand on our own. We need to take control of our economic destiny. And when I become Attorney General, we will. So the second thing that we have in our incumbent and in the culture of the political culture of the incumbent represents, which is being a career politician. He's been in office 24 years, 12 as deputy AG, 12 as AG. You should never become comfortable in office.
Right. Agreed.
He sits on the land board, and the Idaho Land Board controls 2.4 million acres of Idaho's lands. They administer them for the trust for the public schools. But in the process, his interpretation of the Constitution is that the land board is required to compete with private business by buying commercial properties. Government should never compete with private business. We have a name for governments that own private businesses, and it's not a nice one. We don't want that in Idaho. It's simply not, not the function of government. It's not proper. It's a violation of the duties of the constitutional officers. And I intend on sitting on the land board to stop that.
That's
right. The third aspect of the third thing that caused me to make this decision was just watching what happened with Obamacare in Idaho. We passed a Health Freedom Act, and it is actually incorporated into the duties of the Attorney General. It's right there in the list of duties of the Attorney General to enforce the Health Freedom Act. And that means that any law that's passed that would mandate that Idahoans buy health insurance is to be opposed by the Idaho Attorney General under the Health Freedom Act. But when the Supreme Court said, well, it's not a penalty, it's a tax, our Attorney General said, well, then everything else is moot, the Health Freedom Act is irrelevant, and I'm not going to enforce it. And as a result, we have a state health insurance exchange and mandates and penalties that are going to be imposed next year. I say we need a new Attorney General who's going to oppose the penalties and mandates and act as other Attorney Generals in other states have and challenge the constitutionality of that law. Case that I handled with the Attorney General's office was just last year, and it has to do with health care. I represented a medical sharing expense ministry. That is, it's an exception to Obamacare. It's an opt-out for Obamacare, and it's not considered insurance, except in the state of Idaho. The Attorney General's office and the insurance department considered it insurance, and they declared that it was illegal for my client to have a medical sharing program available to Idaho citizens that would allow them to opt out of Obamacare. I had that struck down by the Idaho Supreme Court, and in its decision, it stated that it was classic overreaching on the part of the Attorney General's office and the insurance department. You should not have an Attorney General who does not know that he serves the people.
That's right.
Yeah.
We have an Attorney General who has,
Complacent in his job.
That's exactly right. Back in 2006, our Attorney General has not been opposed for 8 years in this office. And as a result, there are a lot of things that people just don't know about his office, and I'm going to tell you one of them right now. In 2006, there was a case that was of great importance to all of us. As far as I'm concerned, the Second Amendment is the only defense that we have for the other rights that we have. I believe in a constitutional right of open carry. And our Attorney General, in 2006, had the opportunity to join in briefs on one of the most important cases that has ever come down. It was known as Heller versus District of Columbia. In the Heller case, the question was, does the Second Amendment provide for an individual right to bear arms or just militias under state law, or state militias? That was the question. An important question, a terribly important question. In the Court of Appeals, the case was called Parker versus District of Columbia. And when it was Parker versus District of Columbia, our Attorney General, their office, joined in a brief. The brief they joined in that case, in Parker, they joined with the Commonwealth of Massachusetts, Maryland, and New Jersey, and the cities of Boston, Chicago, and New York. On August 6, 2006, they filed a brief that said this on page 2. The Commonwealth, on behalf of itself, the states of Idaho, Maryland, and New Jersey, and the cities of Boston, Chicago, and New York, writes to provide the court with a view of states and cities that do not accept the assertion that the Second Amendment restricts a state's rights to determine gun policy within its own borders. Appellants, that's the other side, and their amici are simply wrong that the Second Amendment provides an individual right to bear arms. Federal and state court decisions have almost uniformly rejected their arguments. An individual right to possess firearms is dealt with in state constitutions on a state-by-state basis. It is not and has not been a federal constitutional right. Ladies and gentlemen, that was your Attorney General in 2006 speaking for the state of Idaho about you not having any Second Amendment constitutional rights. But that never got known by anybody. You know why? Because the statesman never put it in. Our Attorney General was not opposed. He had no opponent in 2006. But lucky for all of us, this brief had to be sent to everybody who had filed an appearance in the case, and one of those was the NRA. The NRA got this brief the day after it was filed. 5 days later, our Attorney General's office filed a motion to withdraw Idaho from this brief. And they said, oops, we made a mistake. This was filed in error. Now, ladies and gentlemen, you don't make mistakes in deciding to file in a case that's going to the Supreme Court on the Second Amendment and our rights. You do not make that mistake. And if you do, you should not be in office. So, ladies and gentlemen, I ask you, do you want an Attorney General? Because eventually, you know, they then in the Supreme Court, they decided, well, we better sign on to Texas's brief, and they did. So they got on the right side of the equation. But here's the question. Do you want an Attorney General who you have to be looking over his shoulder to know where he stands? Or do you want one that stands in the same place for the same things consistently, as I have for 37 years? I think the answer is clear. You need to have someone who understands he's a servant of the people, who understands that we have fundamental rights that are in extreme need of protection. I will aggressively defend the Constitution and your constitutional rights. I will aggressively pursue getting the federal government and the EPA out of Idaho. I'm not a career politician. I'm too old to be serving too many years anymore. But anyway, I'm not a career politician. I have no interest in creating a career out of this. But I want to preserve for us, for our children and our grandchildren, the same values that we all cherish. I want to serve in honor and integrity, and I ask for your support to make you the next Attorney General. Thank you.